Greetings and welcome to the entrepreneurial journey. I am Aziz Makhani, small business advisor with the Small Business Development Center Network. I'm also a racquetball player and an instructor, so if you're ever in the Pullman, Washington area, by all means reach out to me and I'll be happy to give you a game or two. Today's presentation is about protecting your intellectual property, and certainly if you're not going to be protecting your intellectual property, and I'll explain that all to you, whether you need to or not, but to be aware of it, because if you're not protecting it and someone else is protecting it, you may be infringing on their territory, and you need to be aware of it, and you need to understand what the consequences of that might be. So today, I'm going to be talking about trademark, copyright, patent, and trade secrets. I look upon these four factors as a pyramid, and on the bottom of the pyramid is trademark, followed by copyright, followed by patent, followed by trademark, followed by trade secrets. So each one of these have its nuances and what it does, and you need to understand what it does, what the pros and cons of each of them are, and so that you can make an appropriate decision on whether you want to go ahead and file it yourself or not. So that's a fundamental premise of this presentation. Again, I repeat, I'm going to be talking about four things: trademark, copyright, patent, and trade secrets. First of all, our commercial system, if I should say, or economic system, permits copying. In fact, it encourages people to copy until and unless you protect it. And when you protect it, what it gives you is not a monopoly, but what it gives you is a permission to sue or permission to pursue a lawsuit. So fundamentally, if you are unable or if you don't have the resources to pursue and defend your intellectual property, you may not want to necessarily pursue each of these options. So let's now understand what each of these do. Trademark is something that you receive and you register, if you want to, again, for your company name, company logo, company slogan. Those are things that can be protected through a trademark. The next step up is copyright, and copyright is anything that's intellectual property, such as a song or a theme or commercial that you may produce. Those are copyrighted material. Any brochure that you create, any website that you create, those are your intellectual property, and therefore they fall under the copyright. The next level is patents. Patents allow you to protect your invention. That means if you invented, let's say, a vacuum cleaner, a unique vacuum cleaner that somebody else never thought of, a unique way, you would then protect it with a patent. You would trademark the name of that particular product. And if you were to pursue let's say, a television commercial, you would own the copyright to it. And if you put in any jingle on the commercial that was unique to you, then that would fall under the copyright. And the last but not the least is trade secret. That can be protected through just keeping things secret. For example, Coca-Cola, Tabasco sauce, those things are trade secrets as far as what's in it, the process of making it, what's the ingredients of it. And so the way that you would go about doing the trade secret is through those people who are familiar with it, such as people that may be employees that know the ingredients. You would then have them sign a non-disclosure agreement. You would have them under strict, not scrutiny, but strict compliance of the non-disclosure agreement, and that way you would be protected. Trade secrets is certainly the easiest route, but the most difficult in terms of executing it, in the sense that you would have to have employees comply with it. The compliance is the main thing here in the trade secret. I understand that I'm bouncing between one and then the second one and the third one and the fourth one, but I hope you're getting the gist of what each of them do. So back to trademark. There are two different ways that you would trademark. One is through the state where you would be operating. So for example, if you were to simply operate your business within the confines of a state, say for example Washington State, you could get a trademark that was specifically applied to the Washington State, and you would be going out and getting the trademark through the Secretary of State website. On the other hand, if you were not limited to a certain region and you were to go about using your trademark and you practice your product or your services, you sold your products and your services across the nation, you may want to pursue the trademark through the USPTO, which is Patent and Trademark Organization. And applying for trademark can be pretty simple if you were simply to trademark a name, whereas if you were to trademark how it appears on your product. Say for example, if you had a logo that had a specific color, the best example of that would be, say, Coca-Cola, how the Coca-Cola is written and the colors of it, the red and the white, and how it blends, and then you would have to describe the curvature of the curve of the font and the specificity of the name Coca-Cola on your brand name. So that way you would not be infringing if you had a Coca-Cola name. The Coca-Cola is very specific to the way that it shows up all across the world. So what they have done is they have gone out and pursued trademark affiliation with all the other countries as well. My point being that in a trademark, if you didn't apply for a trademark, you could simply say next to your name, actually as a superset, as a subscript, you would say, I'm sorry, superscript, you would say TM, capital T and capital M. That basically says you have declared this particular mark as your specific trademark. Now, that doesn't give you the legal right or the opportunity. It's not as strong as if you were protected through you had it registered in the USPTO or the Secretary of State of Washington. So it's not as strong. But remember, enforcement of that trademark, the fact that you have actually owned it, is only as good as you are willing to defend it. Now, on the flip side, if you used a trademark of a company, if you had not registered and you used a trademark of another company, that company could come and ask you to cease or desist or could ask for financial compensation. So not only would this be a high inconvenience, but it could also be a high penalty. So that's the flip side of you not going through the route of getting your company name or company logo not trademarked. Now I want to take this moment to also tell you about your domain name, your website domain name. The website domain name goes through another process entirely. It does not go through the trademark process. It goes through a domain name registration. And that's done through a variety of domain name registration sites that are on the internet. That's a subject of another discussion, but I just want you to be aware of it so that when you select your name, when you select your domain name, hopefully you can defend it and you won't be able to be inconvenienced by another company pursuing it. Now let me talk about copyright. Copyright has lately become a really major area because many people would want to, for example, go out and get an image from the internet to put on their website or on their brochure. Now, when you do that, does this mean that you are not allowed to do it? Of course, you are allowed to do it, as long as someone who owns it does not know about it. Can you use a music that's written and sung by another company? Sure you can. It's only as good as long as you are a small entity and the party that owns it does not know of you. The most famous one, of course, in my opinion, copyright infringement is one of music. Led Zeppelin was pursued by a company, by another musical group, and they finally had to settle. And these kind of things happen in musical and artistic arena all the time. So what you want to be aware of is that you are not trembling on someone else's artistic creation. As far as what you need to do personally, just because you created it, and if you were to create a website, you can simply put down copyright, and you don't have to go out and register. You just simply say copyright, your company name, and the year that you created it, and that's plenty enough. If you created a picture, and created your own music. By the way, that's one way to get around everybody that you may potentially infringe on, is create your own music, create your own picture, instead of using or basically, I don't want to imply you're stealing it, but basically that's what that is. So instead of doing that, what you can do is create your own so that you're not trembling on anybody else's area and anybody else's invention. The third thing I want to tell you about is patent. Patents can be very costly. Oh, by the way, as far as the cost go, trademark is, if you were to do it, $200 to $400 through the USPTO, another less than $100 for the Secretary of State in Washington. And if you were to hire a lawyer, you should expect about $500 to $1,000. So it's not a formidable cost, but it's something that you can do it, or you can hire a legal representative to do it. Copyright, I've already mentioned it. So on the patent, there is, first of all, there's a patent search process. By the way, you can do this on the USPTO website. You can do the search through the internet, or you can hire a legal entity that specializes in patent law to do that for you. The cost of creating a patent for a product or a service can get pretty formidable. It could run anywhere from $20,000 to $60,000. I will give you a number. 97% of patents that have been filed have not even recovered the expense of creating the patent. I certainly don't want to discourage you from creating the patent, but consider the cost and consider the benefit and consider the consequences of not doing it. Now, on the flip side, if you were unknowingly infringing on someone else's patent, understand that you may be infringing on them, and if they were to execute and if they were to pursue a legal recourse against your company, you would be facing some consequences. So just beware. The websites that I would refer to you are USPTO and the Secretary of State. The last thing I want to talk about today is trade secret. Earlier in my presentation, I talked about trade secret through your employees. The most recent example that I want to tell you about is Tesla pursuing a company in Michigan, a startup of electric vehicles. And Tesla is pursuing that company because that company is hiring key employees out of Tesla with the knowledge and information, and in fact asking them to bring some of their knowledge with them. So Tesla is pursuing them aggressively, and that's the one that's made the news lately. So information such as, you could protect information such as customer list, contacts, information on how your ingredient is, if you were creating a edible product, or the process of making, let's say, a boat, a certain way that you're creating a certain widget. So there's a broad area that you could have it protected through the trade secret. Again, I want to remind you that trade secret is a way that you would do it through tight relationship with your employees, having them sign a non-disclosure agreement, and then understand that that this process requires a full understanding between you and the employees, information that you want to protect. So, so today I've covered a broad area. I hope I've given you enough information about both sides. Information about you pursuing an intellectual property protection yourself, and the other side, if you were not to do that, what the consequences might be. And I hope that you enjoyed the entrepreneurial journey as I have in my career. Any questions or comments or clarifications, by all means, reach out to me and I'll be happy to share that with you.